called Immigration and You. Well, Legal Times is pretty much going to be the same format, but we're going to be dealing with a lot of different and separate issues. Firstly, I would like to say happy birthday to Daryl Nigakwe, cuz I hope you have a very happy birthday today. And one of the things that we are going to be discussing um, on this program is a variety of issues, everything dealing from immigration to real estate transactions to real estate litigation. Um, and I do apologize since this is the first pilot program. What is happening, you'll see me looking left, right, and center. And even though I know it's coming over the radio on 96.1 in Guyana live, they won't be able to see, but at least you can listen. So even if you see me switching or pausing, it's because I'm dealing with the calibration of studio equipment and so on. So the first thing is, let me properly introduce myself. Once again, my name is Nigel Blackman. I am an attorney at law. I'm one of the attorneys at Eastbrook Legal Group. You will be meeting my other partners fairly soon, as we will be taking turns providing information and answering any questions that we have or that the public has that we can answer for you to make your daily lives a little bit better for the understanding of what the laws are in relation to certain legal topics. Now, as everyone knows, in the Caribbean, I am normally known as an immigration attorney, but it's not the only thing that I do. However, I do find that it's a very popular issue. There are a lot of problems, a lot of misunderstandings with regards to immigration laws, in regards to processing of immigration cases. So what you can do is, if it is that anyone, whether you're hearing this on any one of the radio stations or looking at it on Facebook, if you wish to ask me any questions while I'm on live, and even after it is that we get off of the screen, then please feel free. You can make your comments. I will try to go down the list and answer them. So as far as Facebook is concerned, YouTube, IG, you can simply type in your comments and I will answer them. You can also go and join the page of Eastbrook Legal Group on Facebook, and you will always be able to have access to me and my team. Okay. Presently, we have offices in New York, Guyana, and Trinidad. And we normally serve in those areas, especially in dealing with immigration law. We deal with mostly a lot of embassy and consulate affairs, a lot of immigration filings from overseas. Guyana is normally our back office where we do a lot of the production of the work. Anyone who needs to see me in New York, you will be getting, hi Kay, how are you? You will be able to see or meet at our office in Manhattan. The address you will see and all the contact information you'll see at the bottom of your screen shortly. And you got to excuse me, like I said, it's the first pilot program. So what happens is we're doing a lot of maneuvering and so on. Now, this program is probably going to be on about 3 to 4 times per week. If you have any questions, that require answering either during the program or after the program, you can get in contact with us via comments on the program live itself, or you can get you can probably get a direct contact through WhatsApp at 718-450-1552, and I'll repeat that during the program. You can also get us via email at inquiry, INQUIRY, at eastbrooklegalgroup.com. Or you can visit the website and leave a comment at Eastbrook, www.eastbrooklegalgroup.com or eastbrooklegal.com. Okay, so you can check that out. We will try to respond to every question as it comes in, and try to provide the best answer to your question to the best of our abilities. Okay. Now, one of the discussions that we're going to start with today is immigration. And we're going to be talking about family-based immigration. It's in the immigrant communities around the United States and even other parts of the world. There are a lot of situations that are happening where people do not understand what to do or what's happening. And one of the things that prompted me to bring this program back and online is, especially as we were coming out of the COVID period, I began to get a slew of calls asking the same questions as before. So we had a conference and we've decided to bring the program back. And now that there is the ability to have an online platform, we figured that we can try to reach more people and get questions answered as quickly as possible. Okay, so before we jump into it, the issue surrounding family-based immigration processing is to first discuss the actual processing so that people understand where your matter is and what is supposed to be happening at that location. Okay. Now, most immigrant petitions or most family-based petitions are commenced by the filing of an I-130. Good morning, Tyson. They're mostly done by filing an I-130 or an I-130A, along with a couple other new documents attached to the original petition. And that application is normally filed with the USCIS, United States Citizenship and Immigration Services, at various locations based upon the jurisdiction where the petitioner lies in. So take, for example, most of my cases come out of the state of New York. So therefore, the Vermont Service Center has jurisdiction over that. That is where it is that we file the petition. Now, once the petition is filed, what happens at that location or at these locations that have jurisdiction is their job is to establish that the petition that has been filed is good and that the basis for the petition is proper. For example, to take a basic case where a husband files for a wife, the things that they check for is that, number one, that the individuals have the capacity to be married in the first place. Number two, um, that they are in fact legally married or lawfully married, and that there may be a bona fide, or that the issue of the bona fides of the marriage is there. Now, different rules will apply as to whether you're in the country or out of the country, meaning the beneficiary of the petitioner, beneficiary of the petition. Different rules may apply or different things may happen. But normally what happens at USCIS, you file your petition, you pay your filing fee, and you check to see, and they will check to see whether your petition is good and proper, and whether all the legal qualifications exist. Okay? Then you get an approval of your petition. The approval of the petition does not confer any benefits upon the beneficiary who is normally outside of the country. It's merely that the petition, that they've examined the petition and that the petition gives the legal qualification for someone to receive a permanent resident visa. After it is approved, it is then forwarded to the National Visa Center, or the NVC. More than likely, you will see me make reference to the NVC. If I say NVC, that means the National Visa Center. Okay? And the first thing that the National Visa Center, in most applications, or most if not all family-based applications, are going to request from you an affidavit of support. Now, let me just take 1 minute, because my people in the Caribbean, we normally make reference to, well, we got the first paper and then the second paper and then the third paper. So what I want you to do is to stop looking at it as the first paper, the second paper, the third paper, because it can be confusing and it can be misleading. And a lot of people normally, when they come to my office, they say, well, we got the first paper and then we got the second paper. A lot of people don't really know what that is. The first paper is normally the notice of receipt after filing. That's just the notification that the petition has been received. Okay? And a lot of times we find that we have to decipher that from common usage and common language as to what or where and what has been received, and what it actually means. So normally, if it is that you're going to head into, let's say, an attorney's office to seek advice about the nature and process and standing of your case, one of the things that you should be doing is to have a copy of the documents, rather than referring to, well, we got a first paper, then another paper came, and so on, because it's very difficult to decipher and to tell. And then you may end up, if it is that the lawyer is assuming what document you are talking about, the information that you get can be bad or not good or inaccurate. Okay? Now, when the document goes to the NVC, or when your case, your approved petition, proceeds to the NVC, then what happens is their job at the NVC is to package all of your documentation. That's all it is. It's not a place where you can adjudicate something. It's not a place where you really go to ask questions. Their job is to send out information to you and to gather. You were to send them the information. They gather the information up, they package it, and then they send it to the embassy. Okay? So right now we have two entities that have been involved. Okay? You have USCIS, which is the Immigration Services. Then you have the National Visa Center. Okay? That's our second entity. Okay? And like I said, NVC's job is to accumulate the information, to create a package, and then send it off to the embassy. Okay? And this is if it is that that the beneficiary is in a foreign country. Works a little differently if the beneficiary is in the United States, but we'll get to that when it is that we have the discussion on adjustments of status. Okay? Now, when it is that it gets to the embassies, they receive the package, and the package, the nature of the package, has been there for you to provide documentation which will give rise to issues of admissibility or inadmissibility. Okay? And the inadmissibility grounds are several. So take, for example, and when I say inadmissibility, when it gets to the embassy, you will then have an interview. And sometimes there is a denial of the petition. When it is that the petition is denied, they will normally tell you that you were inadmissible because of X, Y, or Z ground under a particular law, and so on. When we have our discussion on inadmissibility issues and how it is that you can litigate them, you will then begin to understand a little bit more. That'll probably be more than likely on the second program or the third program, depending upon how fast we can get through. So once again, once it gets to the embassy, it is then what they call adjudicated there. And you could be approved, you'll be denied. So you have three entities that take jurisdiction over these cases. The first one is dealing with processing of the petition. The second one is gathering the information. And the third one is making the final decision or the adjudication on your case. Okay? If it is that your petition is granted, or the application, at that point, that the application for admission is granted, then you will receive a visa. If the application is denied, you will receive a denial with a particular, it's supposed to have the particular ground for which it is denied under and the reason for the denial. And thereafter you'll know whether it is that you can challenge the denial if necessary, or if there's other things that may need to be done, right? Or some people just leave it alone and walk away. Okay? Now, the first thing that we're going to discuss after I've just explained the processing to you is the types of family-based immigration. Okay? Now, the first one, which we all know, is the immediate relative category. Okay? The immediate relative category is normally a spouse of a U.S. citizen, a child of a U.S. citizen, or a parent of a U.S. citizen. So if you have a child that is under the age of 21, right? That is an immediate relative. If they are over the age of 21, they are not considered an immediate relative. They are not considered a child. They're considered a son and daughter, which is a different category. So children are, for the purpose of immigration, are under the age, or individuals who are under the age of 21. Okay? Now, once again, as I explained that, if you have any comments that need, that your questions that you need asked during the program, you can type it in your comment section on the social media platform. It should be able to come through to me possibly in real time, and I will see if it is that I can answer the question for you. You can also get me on WhatsApp on 718-450-1552. I may not be able to respond to that one immediately, but I can definitely take a look at it and we'll be able to get back to you. Otherwise, you can also make an inquiry at the inquiry@eastbrooklegal.com or go to the website. Okay. Now, the second part of the immediate relative category is the spouse of a U.S. citizen. These are categories, these two categories, the child and the spouse, they don't have any numerical limitations, meaning that they should be very quickly processed for U.S. citizens get those benefits. Now, also as a parent of a U.S. citizen, they are also included in that. They don't have any numerical limitations on them. The other categories, which we are going to go through in a second, those have numerical limitations. And what I mean by a numerical limitation is that there is an annual amount of visas allotted per annum, okay, for each category, with the exception of the immediate relative of U.S. citizens. So every year, the government allots X amount of visas for the other categories. That's why we're seeing now we have such backlogs. Okay, for anyone who has filed for a relative who is not a U.S. citizen or an immediate relative of a U.S. citizen, you're finding those time periods are getting longer and longer and longer for your relatives to get here. Okay? And the reason is that the embassies, or the system, I should say, it's not necessarily the embassy's fault. The system has become backlogged. So unless they still have to finish the initial allotments before it is that they can move on to the next set of allotments. So, like, for example, many years ago, you would find in the category of, let's say, unmarried sons or daughters, the application would probably take, or unmarried sons or daughters of U.S. citizens would take a relatively, maybe 3-4 years. Now, it's not that any longer. It has now increased. It is now, you're talking about maybe 5, 6, 7 years. In other categories where it would have taken, 3-4 years, it is now 8, 9, 10 years. And that's because there's so many visas in those visa applications in those categories that are being processed that they can't get through them all within each calendar year. So it then falls over to the following year. And as it falls over to the following year, you still have a new set of visa allotments for that year, but they still have to finish up the backlog. So as each year is rolling and rolling and rolling, you find that the wait times are becoming longer. Okay? I don't know if you all can hear me. I'm seeing some comments where the volume is not good. So if I can get some feedback, especially for the radio station, if anyone is listening. Okay. So now as we move forward, we have our second category, okay, which is our first preference category, which is unmarried sons and daughters of U.S. citizens. Now, if you can recall, a few minutes ago, I had just stated that we use the term child of a U.S. citizen. And now you're seeing that I'm using the term sons and daughters. Sons and daughters are individuals who are over the age of 21. The term child means anyone who is under the age of 21. Okay? So we have unmarried sons and daughters of U.S. citizens, which is our first preference category, out next under the immediate relative category. And there are certain rules that need to be adhered to in this situation. For example, if it is that someone is an unmarried son or daughter of a U.S. citizen and your U.S. citizen parent files for you, at the time that you that your case is adjudicated and you go to the embassy for your interview, at that time you also should be still unmarried. There are situations where um, individuals become married during the process. If it is that you become married during the process, then you need to let the service know or let the National Visa Center know that you have become married during the process so that they can reclassify your visa application, okay? Or or upgrade or downgrade the petition itself to what it should be. Because at the end of the day, if you go in to the embassy without reclassifying your visa application or the petition, then what happens is you will immediately be denied. And it's happened to tons of people. We don't realize, we just think that the visa petition is going to come through. So if you're filing as unmarried, you should be unmarried at the time of the interview, because at the time of your admission to the U.S., you need to be within the category that the petition has been filed for. Okay? So always make sure that you are maintaining the status for which it is that you've filed under, okay? Because it can cause some issues or problems for you, and you don't want that to hamper your situation, because really what's going to happen is that you're going to have to start the process all over again. There is no appeal for that stuff. It just needs to be caught before it is that you have your final interview. Okay? All right. Now, the second preference category is spouses and unmarried sons and daughters. Spouses and unmarried sons and daughters of permanent residents. So permanent residents can actually also file for their spouses and unmarried sons and daughters. Once again, you have to remain within the category of being unmarried, or else you will have a problem at the embassy. If you become married for whatever reason, then you need to submit, more than likely to the NVC, proof that you have become married, right? And if that happens, you may end up moving to a different category, okay? So then we have as our third preference, which is going to be married sons and daughters of U.S. citizens. Now, once again, if it is that you are married at the time and that you are over the age of 21 and child of a U.S. citizen, or the son and daughter of a U.S. citizen, if it is that you become divorced during the process, you need to alert the service, or you need to alert NVC. You need to alert the service so that they can amend your petition if they become married or unmarried during that period of time that the petition has still not yet been adjudicated. If it has been adjudicated and approved, then you need to alert the NVC. But for whatever you do, you need to ensure that the issue is, or that your correct category that you are in is settled before it is that it goes to the embassy. And then the final category is brothers and sisters of U.S. citizens. And this takes the longest process. As I've moved down the line, the process takes longer and longer and longer and longer. And for example, wait times right now, and I will use Guyana and Trinidad as my point of reference. Those wait times, we are now looking at time periods in excess of 11, 12 years waiting. Okay? So those are things that those little issues as to how things are classified, you need to be very careful with, because I've seen a lot of people who walk into my office. They're very upset. They've just come from the embassy. The embassy has denied them. When it is that they're questioned, you find either A, that they either got married or they got divorced. They didn't change their category. Okay? Um, Now, there's a couple of little issues that I wanted to go over in relation to the matter of like children, okay? Because it's a major problem, or it can be a major problem. If you have, let's say, a child of the house or a child of the home, a lot of us, we take in children and we raise the children as our own, and we call them our children. We may even do a deed poll, which for many people, they believe that a deed poll actually changes the status of the child. It doesn't. Deed poll, which is an Old English statutory declaration, um, it basically, all it is a statutory declaration that either there is a name change, okay, or that you are changing your name, or that you are changing this child's name, and so on. But it does not confer any legal benefit for the purposes of immigration. So someone could have had a child in the home, and the perfect example is, let's say you took in, you have a person of a wonderful heart, and you had this maybe a foster child that you decided that you wanted to be your own child, and you brought this child up as a child of the home or as a child of the family, or you may have taken a relative's child in and raised that child as your own. You go, you do a deed poll changing that child's name or last name to your name. That does not make that child your child for immigration purposes. You have to legally make that child your child. A deed poll doesn't do that. The only thing that can do that is a legal adoption. Okay? You need to have an order of adoption. When it is that we're going through the issues of how to do the adoptions in the foreign countries and also in particular states, I will then get into the differences between the different types of methods to deal with the adoptions. Or maybe we'll get Denise Melville on, because she's done a lot of the stuff with relation to the Hague Conventions and how it is that it's affected adoptions in different countries. Okay? And just on another note, so that you know, a lot of people think, oh, I'm going to go take my grandchild and I will adopt them. I want to adopt my nephew. I want to adopt my niece. I want to, I've got this child and the child's being ill-treated and I want to adopt them. And then they find out that when they get into the embassy for the interview, that the petition is denied. Okay? Sometimes, or sorry, the application is denied. I'll get into the nuances between an application and the petition. Or sometimes the petition at the beginning stages is denied. Okay? Because there's certain legal qualifications that need to be proven in order to consider a child for immigration purposes. Other than that, they will not be considered a child for immigration purposes. Okay? So be very careful with the adoptions. There's other states that have a statute in their family law provisions that states if it is that you are trying to adopt a child, to bring the child into this state, then you need to do X, Y, and Z. So you may have to go through a two-part process, right? In the family court in that particular state, and states like New York are one of those states, okay? Depending upon the particular situation. You may have to become a qualified adoptive parent, right? In the family court, and also have an order of adoption uh, from your home country, okay? So just be careful, because a lot of people kind of go willy-nilly, and they think that just because they have an adoption decree, um, that they can go ahead and just file. There's residency requirements that are also applicable. A lot of people have been denied, and it's then subject to litigation, where it is that what you thought was originally going to be a very easy petition has now become complicated, because now you may have circumstances where it is that you have to prove that not only did you take care of this child, um, but that you have actually fulfilled the residency requirement. And residency is a term of art which can be established in different ways, but that's going to be for another program. Then we have other issues, such as if a child is born out of wedlock. And this is very, very, very prevalent, because we have children that are born out of wedlock, and let's say the mother or the father gains an immigration benefit, and they would like to now file for their child. Now, normally when it comes to the mothers is not really that much of a complicated issue. You simply just need to prove that the mother and child are in fact mother and child, and there's normally not an issue there. The issue normally comes up, especially when it involves the fathers, okay? Especially if it is that if you were born out of wedlock, and let's say your father is a U.S. citizen and he would like to file for you. What happens is that there are times when it can become a bit difficult, because we have situations where the father has not signed the birth certificate. The father has not proven paternity. He has not taken any steps to legitimate the child, and we're also dealing with legitimation issues, okay? There's certain steps that need to be taken before the child is of a certain age, which then legitimates the child for immigration purposes. Okay, there's some ancient laws on the books in the foreign countries which makes differentiations between legitimacy or legitimate children and illegitimate children, and how it is that they are treated. Similarly, in certain provisions in the federal immigration laws of the United States, there are one or two issues of legitimation. And those come about, or not that it comes about, those can be dealt with by showing, A, that the paternity was established at an early date or before a certain age, and further, that the father may have taken financial responsibility of the child, which will give further credence to the fact that he has the ability to file, and that he's taken responsibility for the child, and such showing that the child is in fact his child. A lot of people don't meet their fathers, or their fathers have nothing to do with them or be a substantial part of their life until sometimes they're after 21. And when it is that they have to now prove that they've either been legitimated, or that paternity, that there is evidence that paternity was established prior to a particular age, they then have problems. Okay? So we need to look at those issues in a very specific manner, okay? Because they can and do lead to substantial litigation, which can be very expensive and very time consuming. Um, so we have a question on the board. Well, we didn't discuss this topic, but naturally it always comes. Um, it's about a B2, B1, B2 visa, and they're asking why it is that they've been denied 3 times for a visitor's visa. Now, I can't get away from this from this question. And no matter what I talk about, everyone is interested in why it is that they were denied their visitor's visa. So I will make this statement once. I know that I would like to make it once. I don't know if it's going to, I know that I'm going to be asked it again and again and again and again and again on every show that we deal with immigration, even if we're not discussing the issue of the visitor's visa. Okay, so this is how I will put it. When you fill out the application for the visitor's visa, what you are in fact doing is you are submitting an application for admission to the United States, okay, for the purposes of pleasure or for business, hence B1 slash B2. One is business purposes, the other one is for pleasure, but they're both within the same category, meaning that you have to prove and establish the same thing. And what it is that you are looking to establish, and what the embassy officials or the consular officers have to try to assess is whether you have an intention to abandon your residence in that country, and whether you have an intent to return to the home country. Now, the personal problem, and this is personal to me, the personal problem that I have is that it is almost impossible for anyone to prove in a few words in a single or even multiple page application where there is not too much personal information, or space for personal information to be provided, that it can assist someone in establishing that you are in fact admissible. Now, we've seen situations where people have been denied, and I've known people who have been denied, many, 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 many times. And what happens is they come in and, they, morning Gail, morning Chevy, morning Priya, morning Marlon. Um, they come in and they don't understand why it is that they've been denied. And you kind of take a look at the application. And you run through the application, and then you question the client or the potential client about their background. Now, when you question the potential client about their background and their personal circumstances, none of these things are written on the paper or written on the application. So the question is how would the consular officer be able to know that or know these things about you? That, there are people who sometimes they just want to have access to certain things. They have businesses, they have assets, they have things going on that would indicate that they really don't want to stay, and a lot of them don't want to stay. But I think for those applicants who have gotten their visas and have violated the terms of their visas by not returning or doing other things in violation of the terms of their visas, they have made it difficult, or they've added additional scrutiny to the applications in assessing inadmissibility or admissibility, right? And those terms, admissibility or inadmissibility, is a separate issue, which there's many different grounds and so on. But the consular officer is granted a lawful discretion, okay? That person has to use his discretion, his or her discretion, in granting or not granting the visitor's visa, okay? Now, it's a lawful discretion that really cannot be challenged nor appealed, unless it is that one can establish that for grounds of race, religion, ethnic origin, or whatever, that they have been denied, then those reasons are the only reasons that are challengeable by an appeal. Okay, so you have to kind of get your stuff together and understand what it is that you're getting into when it is that you go to one of these interviews. So to answer your question, I don't know why. I don't know your particular situation, but you can, feel free to either make an inquiry. I can probably take a look at it and, have a conversation and see if it is that it is worth you maybe reapplying again. But you will not be able to do an appeal on the matter. Okay? But there are things that you should have lined up and ready to maybe even discuss at your interview. A lot of people, we just kind of walk up to the counter and we're talked at or talked to. There's a couple of questions that may or may not be asked. Sometimes the denial is waiting for you when you walk up to the window. And that is based upon the lawful discretion, based upon the application. It can be based upon other items which are in your file. We've had several situations where people's visas either were not granted or canceled because of some issue one person may have had with another, and they knew that they were going to apply to the embassy. They called into the embassy and they said, this person's a drug dealer, this person's a this person's a prostitute, this person's, I mean, you can hear the entire, the reasons are almost limitless. But there's other things that can be in there that can affect a situation. There are criminal grounds for denial. There's health reasons for denial if it's known beforehand, and so on. So you have to be very careful and be very prepared if it is that you are going into a visitor visa interview. Okay, even filling out the application, you need to understand what it is that they are assessing. And what they are assessing is your ability to, or whether you have whether it is understood. I'm sorry, I'm trying to find a very specific terms. Whether you have been able to demonstrate that you are going to return to the home country and that you are not planning on staying or residing in the United States. So sometimes you will see a denial under maybe 214, either 214, section 214 or 212, which may, and they'll tell you, you haven't demonstrated the fact that you haven't demonstrated that you are not going to abandon your residence in the home country. So If it is that you have not demonstrated that, then it means that you probably need to figure out a way how to demonstrate that. Okay, if you want to be otherwise successful in your in your in your interview process. That's probably the most that I can tell you. There's no hard or fast rule. Um, Please, if you go to someone who is filling out your visa applications, please do not let them tell you that this is what you should write on it, especially if it's not true, um, because that can create additional problems for you. Some of those additional problems is that you can be denied for fraud. If it is that you were denied for fraud, then you may have a permanent bar from permanently entering the United States. Okay? So be very careful. I advise you to just tell the truth. You know, say what it is, and that's it. If you're unemployed, say you're unemployed. If you don't have assets, don't state that you have assets. Do not let people provide you with documentation to take in, because if it's verified that it's incorrect, you will have an issue that may never be able to be resolved, and so on, as far as entering the United States. Okay? All right. Now, what I wanted to then deal with as, okay, well, we've got about 10 minutes left. Now, let's say you have a family-based petition, okay? And the applicant or the beneficiary then goes into the embassy and that they are denied. The question is, what do you do? I know a lot of people, especially uh, especially my people in the Caribbean, they don't like to hear denials. They get frazzled, they turn away, and they just want to forget the process. Now, what I believe should be done is you need to be able to get someone to analyze your denial. Okay? Um, your denial basically will state that you are inadmissible to the United States because of ground A, B, C, D, E, F, G, or whatever it is. It will give you the section of the law, which it should. If it doesn't, it may be defective, but there's certain requirements that the denial has to give you. They have to tell you why it is that you're denied, the facts that you're being denied under, and the ground, meaning the section of the law for which it is that you're being denied. Now, there are times when the denials, depending upon who is adjudicating these things, the grounds for the denials don't legally match up to the facts. And sometimes what are considered facts or allegations are not, in fact, the actual facts as was related to the matter. So you have to then be able to scrutinize your application. You begin to scrutinize your application and the denial which came upon it. Now, let's say sometimes they may deny you under a particular ground. That particular ground may not necessarily be particular to you, but it may have been interpreted by the adjudicating consular officer who made the denial. And sometimes those facts or allegations need to be set straight. And once set straight, the decision may be able to be overturned. Additionally, if the decision is not lawfully correct, in that the facts that they apply do not give rise to this particular ground, then what happens is that you can file, which is in effect, it's something like an appeal, but it's merely a request to confirm the decision. And you can normally file what they call an advisory opinion request with the Department of State. Okay? let's take, for example, if it's stated that someone has committed fraud, okay? There are very specific rules um, that govern fraud. So your denial will say, well, you have committed, you were inadmissible under whatever specific ground under 212, Section 212 of the INA, and these are the facts. You've committed fraud. This is fraud, and you are here inadmissible. And sometimes it may even state that you either are subject to a waiver or you're not subject to a waiver, or this decision is appealable um, or not. Now, the first thing that one would do um, is to basically check to see whether the decision was made correctly and whether the section of law is applicable to the matter, and or whether the facts are correct. Okay, so you can challenge it on maybe a factual issue or on the legal side, meaning as a matter of law that the decision was incorrect. And if you go for your advisory opinion request, then what happens is the Department of State will then state they will either confirm the consular officer's decision or they will overturn it, or they will basically tell the embassy that this decision was either wrong or improper, and then it will be overturned, and you should be able to get your visa, your permanent resident visa. In dealing with issues like that, if it is that it goes there, and let's say you don't agree with that decision, then you can then begin to start the legal process with the petitioner in the courts, in the federal district courts in the U.S., or even with the Board of Immigration Appeals. Okay, but a lot of times we see a lot of situations where the decisions may not be lawfully correct, and then those have to move out to the Department of State. Sometimes we ask them to ask the embassy to reconsider their decisions because it is that the facts are not the allegations that have been made denying the application are not really true or factual, or they're not necessarily accurate. Okay? So there's a couple of ways of dealing with the denials. Now, I think I probably got time, 1 minute, to squeeze in another, well, this one is a bit more pertinent, and I will just discuss it previously. Otherwise, if I don't get through it, because the show is almost done, and there's another program coming in after me. So what it is, they're asking, I've been denied my permanent resident visa based upon fraud. There we go. We were just talking about the same thing. What are the steps that I can take? And apparently this was done over a year ago. Okay, well, if you've done nothing within a year, it is possible that you may have lost some right, because there's normally time periods for which it is that we can do these things. You need to first be able to look at your application, get someone to look at your application, and to assess the nature of what it is that they call fraud. Fraud is has a very specific definition with very specific elements, and those specific elements are going to need to be analyzed as to whether they exist or not. That's just the first thing that I would tell you on this issue. There are things that are called fraud, but they may not necessarily be fraud. It may actually be a misrepresentation, and there's different consequences as to whether there's an innocent misrepresentation, a negligent misrepresentation, or an intentional statement that has been misrepresented. And for each of those categories, there's different forms of relief. So you sitting on your paper for a year may not have done you any good, but there's possibly things that you might be able to do because you have 1 year to act on a denial. Okay? There's time periods that you have to do certain things. So what you can probably do is, if you want, you can scan the document over. I'll take a look at it, and we can have a discussion on your document. Okay? Well, I think the 11 o'clock hour is here. For the online stuff, I would like to carry it over. However, for this week or for today, I'm going to stop for today, and because it's also being live broadcasted on the radio stations. And what I will then do is we will pick up, and you'll see the notifications on what day. It could be tomorrow, or it could be on Monday evening. We haven't set the schedule yet. We just kind of wanted to see how this pilot program was going to do. But we will then pick up with the grounds of inadmissibility so that we can, and I will go through how it is that you deal with those grounds. Okay? So everyone have a good day. I know this was kind of quick and shoddy, but we were just trying to see how much information that we can disseminate as quickly as possible. Everyone knows how to get in touch with me. The information is there. So have a good day. Enjoy your Saturday. Goodbye.